and this section of the bill needs significant work.
I call the Honourable Member Moana Maki.
Thank you, Mr Chair, and I want to continue on from where my colleague Grant Robertson left off on part one of this bill, because there are some serious questions that do need to be answered, and my colleague was talking about clause 29B. I want to talk about clause 20A, which amends section 24 of the bill that we passed a mere few weeks ago. And what this new clause 20A says is that each tender must include an application that complies with section 29A1 and be accompanied by sufficient information in relation to the permit offered for the Minister to satisfy himself or herself of the matters set out in section 29A2, all the matters required under section 29B as the case may be. And this raises the very serious question of where the accountability lies for ensuring that the very, very highest standards are met when issuing permits during the tender process, particularly for Tier 1 applications. And I question very much on two levels the ability of this Minister to carry out that function to the satisfaction of the people of New Zealand, because this is the law that governs some very risky activity in some very sensitive areas of both the marine environment and onshore. So we need to make sure that we get this right, Mr Chair. And I have two concerns about the test, being that the Minister must satisfy himself. And the first is that we've seen from this Minister and from the previous Minister that really they are just so desperate for this to go ahead that I don't think that they are going to be applying the kind of stringent standards that the public would expect when determining whether or not they've satisfied themselves. And we saw it with Minister Heatley, who, during the course of the passage of the legislation that preceded this, that we've only just passed into law and are now amending here, we saw that during a process at which time he was in the process of giving himself immense powers under the Crown Minerals Amendment Bill at that time, immense powers to take half the decision-making power on dockland away from the Minister of Conservation. He came into this House and he was saying publicly, naming specific projects that he thought absolutely should go ahead, criticising the Green Party for saying that certain projects shouldn't go ahead, and really opening the government up to serious danger of judicial review, excessive litigation, because there's a reason why the Minister of Energy shouldn't have the decision-making power in that area, and that's because they do have a conflict of interest. They do. And so when we see here again that this is merely coming down to a minister to apply standards that are crucial for the protection of our environment, crucial for the health and safety of our workforce in this area, the same conflict of interest applies. And I would like to know how the Minister is going to manage that conflict of interest, how he is going to manage the fact that his government is so desperate for this stuff to succeed that his government is prepared to do anything to get this stuff going regardless of the risk. How is he going to manage that conflict of interest with now being the Minister that determines whether or not he's satisfied that conditions have been met? Because I don't think he can. I don't think he can. And we've discussed already, this is it for the government. This, pokey machines and asset sales are it. If it doesn't work, kind of in trouble. That's why I question the ability of the Minister to manage that conflict of interest in clause 20A when he's determining whether or not he's satisfied that the conditions have been met to ensure the safety of the environment and the health and safety of our workforce. I really do question it. And there's nothing in the legislation that indicates how that conflict of interest is to be managed. It would have been nice, Minister, to have had a regulatory impact statement on this bill, because that's exactly the kind of thing that I would have been interested to know whether or not the officials had indicated that that was a risk. But we didn't have a regulatory impact statement. on this piece of legislation at all. Why was that, Minister? That's my second question. We're here where you're basically introducing a test that you apply, Minister, that the Minister applies himself. How is that conflict of interest going to be managed? That's exactly the kind of thing that a regulatory impact statement would have addressed. And this is what we get with regulatory impact statements, Mr Chair. This is what we get with regulatory impact statements from the government, so maybe it wouldn't have been that helpful to us after all. It would have been interesting to see how much of it was redacted. It's a great word, redacted, isn't it? It's one that will forever be associated with the National Party, the party of redaction. But the reality is that we need the Minister to answer that question because he hasn't provided the information to allow us to determine that for ourselves. He hasn't allowed this to go to a select committee so that we could ask those questions. He hasn't allowed any analysis of this at all. So maybe a suggestion could be, because my other concern about the fact that this section relies on the Minister satisfying himself that certain conditions have been met and the test for that is up to him, is that this is a Minister who is so incompetent that here we are weeks after we passed the last amendment bill into law, having to fix the amendment bill with another amendment bill to the amendment bill. It hasn't even been enacted yet. Jonathan Young said earlier that we'd learned from the experience since the bill had been passed. Well, it hasn't been enacted yet. I mean, it hasn't even come into force, so I don't know what we've learned, except that a company possibly came to the Minister and asked him to make certain changes or suggested that perhaps the bill hadn't gone far enough. So I would like to know if anyone asked for these particular changes. You know what, it might just be simpler if instead of having amendment bill to amendment bill to the amendment bill, that we just pass a new bill every time a permit's put up that the government wants to pass. And we'll just be honest about it. And for each new permit that the government wants to fast-track, it will just get its own legislation that can go through all stages under urgency. That would just be easier and simpler, because that's effectively what we're doing. In part one, constantly amending legislation to fit in with what industry is demanding from government, when instead what we should be doing is putting in place legislation that ensures the highest environmental and health and safety standards are upheld, regardless of where the permit is, regardless of what it's for, and regardless of who's asking for it. But that's not what we've got. So here we have the Minister being required to satisfy himself, and we don't have confidence in this Minister that he's going to be able to handle that conflict of interest, given that he couldn't even pass a piece of legislation that lasted more than a few weeks before it had to be fixed up. So maybe we could just take out the word Minister and put in Stephen Joyce, because that's the reality. Wherever the word Minister appears, we'll just replace it with Stephen Joyce, because he's the one who makes, or Jerry Brownlee, because they're the ones who make all the decisions in government. That might be more honest as well. But the real problem with this part one, Mr Chair, is that we were sold the original legislation on the basis that Tier 1 applications were meant to be tough. This was going to be a tough, rigorous process that was gone through. And here we are in part one, already, before the bill has even come into force, the last amendment bill, undermining those Tier 1 application processes. Already. It was only passed a few weeks ago. Hasn't even come into law yet. And already we're undermining what the public were told were going to be very, very stringent, very, very tough conditions for those Tier 1 projects. Well, they couldn't even wait. They couldn't even wait a few weeks until the law had come into force to pass these amendments. They're so desperate for this stuff to go ahead that these changes in Part 1 to Tier 1 application processes are already being put into place. And you know, the Minister is trying to say, oh, well, we just missed this in the original process. Well, that was a process that actually went to Select Committee. Can you imagine what he's missed in this bill, given it hasn't gone to Select Committee at all, given how rushed it's been? I mean, I can't even begin to imagine what other mistakes he's made in this legislation that we haven't had time to pick up since it was tabled yesterday late afternoon. Certainly, again, a Select Committee process would have allowed us to see whether what we're doing in Part 1 is actually what the Minister claims, or whether in fact this is a quite deliberate undermining of those strict Tier 1 conditions. And this is an area where you do not want to have loopholes. This is an area where internationally there is enormous litigation So when we start talking about arbitrary tests like the Minister satisfying himself that this has been met or that has been met, with no information about how the very real conflicts of interest are going to be managed, that makes me very, very worried, Mr Chair. And I would hope that the Minister could take a call on this to tell us how he is going to manage those conflicts of interest to protect the New Zealand taxpayers from the litigation that will follow.
I call the Honourable Member Chris Hipkins.
Thank you very much, Mr Chair, and I'm very happy to take a brief